Okay, this is Paul Welke for the Dominion. Section 101 of the Constitution Act 1867 allowed for Canada to create its own national appellate court, which gave birth to the Supreme Court of Canada. Today we are joined by the Honourable Mr. Justice Russell Brown of that body. We thank you for this tremendous opportunity to hear about your experiences on the court. How did you come to be on the Supreme Court of Canada?
That's a good question. I received a phone call one evening while I was serving on the Alberta Court of Appeal, asking if I would agree to have my name on a short list, and I agreed, and a few days later I received an email asking if the Prime Minister could call me the next day, and I said yes, and he called the next day.
Oh, it was that quick?
It was that quick.
Oh wow, that's incredible. Yeah. How does the court decide which cases to hear and make rulings on?
Well, we hear most of our cases that come before us having granted leave to appeal to the parties seeking to bring the matter before us. There's various ways that other ways that a case can be brought to the Supreme Court. The most common way is a case that is brought as of right, where there has been a dissent on a matter that has resulted in the criminal conviction of the court below, the Court of Appeal. In that case, then there's an automatic right of appeal to our court, and so those two kinds of cases make up the bulk of the cases that we hear. But the vast majority of the cases that we hear are cases on which we've granted leave to appeal, applying the test in the Supreme Court Act, which requires that the matter be of importance. So what happens is the files are distributed among panels of the court, panels of 3, who look at it and make recommendations. Often, if there's some disagreement or if it's felt that the entire court should discuss this, it will be moved to the next monthly conference of the court. But barring that, what will happen is they will make a recommendation, and the materials will then circulate throughout the entire court, and we will all have a chance to look at it by a certain date. And if there is no objection to granting leave, or if there is an objection or if there's no objection to not granting leave, in other words, if there's no objection to the proposed disposition of the leave application, then the order will go as an order of the court.
Oh wow, okay. So when you guys write decisions as the court as a whole, how are those authored? Like, how does that decision get made as to who's going to write the majority opinion?
Well, typically what will happen is the Chief Justice will chair, after a hearing, a conference where we offer up our preferred dispositions, each one of us, our preferred dispositions of the appeal. And usually you can get a sense of where things are going there. Is it going to be unanimous, or is there a clear majority? And people will express interest in writing, and at the conclusion of that month's hearings, then writing assignments, which are always subject to the inclination of the person assigned, or if someone else wants to write it, they can speak up. But typically, names are provisionally assigned, and that's how it will go. But sometimes even then, somebody will be assigned, but they'll be speaking with other colleagues, and maybe they'll co-write. Or I may know that I'm going to write, but it's going to be in dissent, or I know perhaps how they're going to decide this, and I might decide it the same way but on different reasoning, so I might still be writing even if I wasn't assigned. So there's the assignment of the majority decision, but as well, you might end up writing even if you're not assigned for whatever reason.
Okay, that sort of goes into my next question too, that you mentioned the dissent. What is the process to craft a dissenting opinion? Is that any different?
What will happen is, after a judge who is inclined to dissent sees circulated majority reasons, and they are still minded to dissent, they will send a memorandum to the members of the court indicating that they are going to write dissenting reasons. And so, and of course, they may not end up being dissenting reasons. They may be majority reasons. And typically what will happen then is members of the court will await those alternative reasons, let's call them,
Okay.
and then see where they fall. But even then, even once you have a set of majority reasons written, or a set of majority reasons and dissenting reasons, the process doesn't end there, because there's often a quite lengthy process of refinement of the judgment by the judge himself or herself, but perhaps in consultation with other members of the court who are inclined to sign on to their decision, but feel that the decision could be enhanced in some way by considering an issue differently, or considering another issue, or omitting a portion of the draft. So it's quite a lengthy process, and drafts go through often a huge number of iterations before it is released.
Okay, so it sounds like there's some consideration of all the opinions before anything is actually published. And, would it be correct to say that maybe a dissent might end up actually just being a concurring opinion once all those things are taken into consideration?
Anything can happen.
Okay, what's surprised you most about being on the court?
Oh. I think the thing that has surprised me are the number of drafts that are generated. The length of time it takes to generate a judgment is really quite considerable. I'd been told that before by members of the Supreme Court, but I didn't really appreciate until I was enmeshed in the process just how long it takes. It's different at the Court of Appeal. We tended to draft decisions a lot more quickly, not because we were doing them hastily, but because often the decisions would be determined by how we applied a Supreme Court decision. And of course, we don't have that luxury necessarily at the Supreme Court. There may be some jurisprudence out there, but often there isn't. But also, just because of the sheer volume, you issue your reasons after a reflective, considered process, but ultimately there's less revision going on, in part because you have to get the decision out, but then also because typically you're only sitting with 2 other judges. Mm-hmm. And at the Supreme Court, of course, there's 8 other judges, which lengthens the process. Even then, even if allowing for the number of judges, it is a longer process at the Supreme Court. And then, once you have the judgment ready to go, then it has to go to translation. If you've written the judgment in English, it has to be translated into French, and if you've written it in French, it needs to be translated into English. Whatever language it's being translated into, then when the translation comes back, you look very closely at that translation as well, because of course that is a jurilinguist's best attempt at replicating what you said in another language, and often there's maybe a phrase or something that doesn't really quite capture it, or in fact maybe even changes the meaning that you had intended to give in the language in which you had written the judgment.
And both are equally binding, right?
Both are equally binding, so it's very important that that the translation be looked over carefully. That's another thing that sort of surprised me. It makes sense when you think about it, but I sort of thought, well, the translation is the translation. But I mean, I speak French. I should have understood that this would be the case, that sometimes you can lose the nuance, or you know, the idiom is different. But that's an aspect of the length of time it takes to process the decision. Now, I should say, I did sit on a French language hearing at the Alberta Court of Appeal, but and so we had to go through a process of translation there, but that was just one case in my time in the Court of Appeal. About between 1/3 and 1/4 of cases of the Supreme Court, I would say, are pleaded in French.
Oh, wow. Okay, well, thank you so much for joining us today. Our guest has been Mr. Justice Russell Brown of the Supreme Court of Canada. For the Dominion, thank you for watching.